The broadcast is now starting. All attendees are in listen-only mode.
Alrighty, hello everybody, and thank you for joining us for today's webinar. My name is Drew English. I'm the program coordinator here at the Exit Planning Institute, and today I'm joined with our speakers, Katie and Timothy from Banner and Witkoff. They'll be talking to you today about intellectual property rights. And just before I turn it over to them today, a few housekeeping notes from me. First off, the webinar is being recorded. It will be sent out via email after the webinar concludes. So please just look for an email from us later today with the downloadable link to that recording. Secondly, these webinars are meant to be interactive if possible. So we ask if you have questions or a chat box or any kind of comment that you utilize the question or chat box during the presentation. That is on the drop-down menu of your GoToWebinar panel. That will alert me that you have a question. We will then wait for the presentation to conclude, and then I will moderate those questions over to Katie and Tim, if there are any. So with that, I'll go ahead and turn it over to Katie and Tim, and we can get started for today. Hope everyone enjoys the webinar. Katie, Tim, it's all yours.
Great, thanks Drew for the introduction. Hi everyone, good afternoon, and thank you for joining us for the webinar today at the start of this new year. As Drew mentioned, my name is Katie Fink, and I'm joined with my partner, Tim Rectine, our intellectual property law attorneys with the law firm Banner and Witkoff. To give you a little bit of background, Banner and Witkoff is an intellectual property boutique firm, which means that we specialize in all aspects of IP law. We have over 100 attorneys across all of our offices, and Tim and I are based in the Chicago office. So today we're going to be exploring with you the value of intellectual property rights, or IP rights as we'll call them throughout the presentation, and how these intangible assets can confer crucial benefits for companies throughout their life cycle. So what we've seen in our experiences when we've taken over representation of clients as they've grown from startups to global companies with sizable IP portfolios is that sometimes at the early stages, companies overlook the IP rights, and doing that can impact the values of those companies as they're growing and potentially seeking investments or seeking to go public or to be acquired, for example. So we're going to talk about those rights and their value, and then with some anecdotes of our experiences. And as Drew mentioned, we invite questions that we'll address at the end, so you can submit them through the webinar formatting. And also, if you have any trouble hearing us, please let Drew know so we can make sure that we address that. So to jump in, today we're going to be talking about the following questions. First, we're going to be talking about what are intellectual property rights. We're going to give you background on the various types of IP rights. Next, we're going to look at why are IP rights valuable, and how do you determine that value? We're next going to consider how do you monetize IP rights. And finally, we're going to explore some real-world takeaways that we've experienced as we've worked with our clients.
Thanks, Katie. And so we want to start with, get everybody on the same page with what we're talking about when we're saying IP rights and what that means. So here to set the table, we want to talk about the various types. So when we think of IP rights, we think patents generally, and those are, a right that covers inventions. Under that, there are the two main types of patents are called utility patents and design patents, and we'll get into what each of those are. The next IP right we were going to talk about is then trademarks, which cover, brand and logos and things of that nature, source identification. And within or under the umbrella of trademarks is what's called trade dress, which we'll talk about a little bit, that can also cover product designs and be a source identification for product designs. Then we'll talk about copyrights, which obviously can relate to artistic expression, TV, movies, literary works, etc. And then we'll talk about trade secrets, which cover information that's kept secret, competitive information that's kept secret. So jumping in, what is a patent? Well, a patent is a government grant for new, non-obvious ideas, devices, methods, and designs. So here we have an example on the right. You can see of a patent for a New Year's Eve ball that drops down and shoots out confetti. So any type of idea can really be patented if you're interested. And so the grant comes from the fact that in patents, they are actually expressly found in the Constitution to be protected. And so the government at the founding started the United States Patent Office, which now issues patents. And what happens is an inventor can, in exchange for giving up its secrecy of it discloses it to the public, and the Patent Office in exchange for that gives certain rights to that patent holder. And what are those rights? Well, that's the right to exclude others from making, using, offering to sell, selling, or importing into the United States the patented invention. And then finally, a patent, just as what we're talking about here, is an intangible piece of property and something that can be of real value to a company. As I mentioned before, there are two main types of patents. The first is called a utility patent. A utility patent is a patent that covers new, non-obvious, and when I say non-obvious, it means it's something that's not an obvious variant of what came before, and useful products, processes, or machines. And the typical way you get a patent, again, it's you file a patent with the Patent and Trademark Office, and then the Patent Office will attempt to locate older inventions that they believe prevent you from getting a patent because it's not new or not obvious. And in that situation, there's back and forth between the Patent Office, and we attorneys call that prosecution at the Patent Office, and you'll hear that word come up once or twice throughout this presentation. And eventually what issues from the Patent Office, if the Patent Office allows the patent to go through, is a set of claims at the end which define in words what the invention is. And what you get from that is a right to exclude, as we mentioned, and it lasts for 20 years from the filing date of the patent application. So it's a limited in time right. You can see this example on the right is a Nike patent that covers their Nike Shox shoes and the technology behind that shoe. Then we have another main type of patents called design patents. And what do design patents cover? Well, they cover new and non-obvious ornamental designs. So take, for example, the example on the right, it's again the Nike, a Nike patent that is a design patent that covers the ornamental design of the Nike Shox shoes. So instead of the underlying technology, it covers how it looks. And it also is a patent that gets a temporary right, and it's a right of 15 years from the issuance of the patent.
So the next IP right that we're going to explore are trademark rights. So what are trademarks? Trademarks are source identifiers or brands. They're how you can tell one brand of the same type of product from another. So using the example that we show here on the slide, Coca-Cola and Pepsi, for example, are different trademarks for soda or pop, and the way you know which product you're getting is based on the brand name or the trademark. Trademark rights can be used to prevent others from using a name that is the same as your name or that is confusingly similar to your name on similar products. And the goal is to protect consumers so that they aren't confused by the source of the products or services that they are getting. And trademark rights are based on use. As long as the trademark remains in use, there's no limit to the term of trademark rights, as we talked about with patents. So the right is perpetual as long as the trademark is used. But the use must be substantially exclusive. So the trademark owner must take steps to prevent others from using the mark or to prevent the name from becoming generic, something that's been a concern at times for marks such as Kleenex or Xerox. So while trademark rights are conferred based on use, there are benefits to obtaining a federal trademark registration. Trademark rights that are based on use alone and without a federal registration are called common law rights, and those are rights that you obtain just by using the mark in commerce. Common law rights are enforceable like federally registered rights, but there are limitations, and a key limitation with common law rights is that they are geographically limited. So if you're relying solely on common law trademark rights to enforce your trademark, you'll be limited to the geography where you're using the mark and where you can establish you have trademark rights. On the other hand, federal trademark registrations provide additional benefits. They provide a presumption of protectability, which includes presumptions that the trademark is valid, that the trademark registrant is the owner of the mark, and that the trademark registrant has exclusive right to use the registered mark. They also provide nationwide priority based on the filing date of the application, so the trademark owner can be presumed to have used the mark first in certain situations. They also prevent others from registering confusingly similar marks. So similar to what Tim was talking about with the process for obtaining a patent for a federal trademark registration, an applicant submits an application to the United States Patent and Trademark Office. And if there's another mark that's already been registered for the same mark or a confusingly similar mark, that prior registration can be cited against other marks. So if you have the federal registration, it can prevent others from getting a registration on a similar mark. And finally, a federal registration allows for the use of the R circle symbol that's shown here, whereas if you're relying on a common law trademark, you would use the TM symbol that's shown at the top. There are several different types of trademarks. The most typical one that you think of is the brand name. So Nike, for example, or Exit Planning Institute. Trademarks can also be for letters or numbers, like acronyms such as NAACP, or model designators such as SM58, which is a type of Shure microphone, for example. Trademarks can also cover slogans, like Burger King's Have It Your Way, or logos. Shown here, for example, are the Nike swoosh symbol, the Apple icon logo, or the mascot of the Monopoly game, Rich Uncle Penny Bags. Another type of trademark that you can get is a color trademark. So Owens Corning, for example, has pink registered as a trademark. Another example of a color trademark is the red sole on Christian Louboutin shoes. Sounds can also be registered. So, for example, the NBC chimes that you hear when you're watching NBC can be a trademark, as well as fragrances. So Flip Flop Shops has a trademark registration for the coconut smell inside the store. And Tim's going to jump in on another type of trademark.
Thanks, Katie. So yeah, trade dress is a sort of a subcategory of trademarks. It relates to source identification, but what it does is it protects the overall look and feel of products, packaging, building stores, restaurant motifs, things like that, that have what's called acquired distinctiveness, which is just a fancy way of saying that the public has come to associate that overall look with a particular source, and that are non-functional. So as an example here, we have on the bottom left, or on the left, it's an image of what some of you may recognize as the Apple store layout. So Apple believes that it has trade dress on the way it's laid out its store design. And what that means is if somebody else, a competitor, sets up their store in exactly or close to that manner, such that consumers would be confused about affiliation or source of that store, thinking it's actually affiliated with Apple, Apple would be able to go against, potentially sue that competitor for trade dress infringement. Another example is we show a Yeti cooler on the top right, and that is Yeti makes nice coolers, and what they have is a very unique design, which you can tell from the image, and they don't want people copying that particular design. So they have a trade dress registration on that design. And then probably the most famous or oft-cited example of trade dress is the Coca-Cola bottle. As a source designator for a Coke. When you see that bottle shape, you know that it's a Coca-Cola. So the aspect of non-functionality comes into play with that there's this tenuous relationship or uneasy relationship between trade dress and patents. So to make sure that, again, patents are for a limited fixed amount of time, trade dress, because it's a trademark type right, is perpetual as long as it's in use. And so courts want to make sure that people aren't taking advantage of claiming something as trade dress when it should be patented and getting a perpetual right. So the law requires that the trade dress be what's called non-functional, reserving functional things for an aspects of a design to the patent law. So trade dress ultimately is very similar to a design patent in that they're both covering ornamental aspects of product designs.
So the next IP that we're going to talk about is copyrights. And copyrights protect the expression of ideas. So they protect things that we typically think about, like music or books or movies, but they also protect things like software or the layout of a website or a mobile app. Copyrights can also be used to protect aspects of clothing or footwear and jewelry. And like trade dress, to be protectable, the works must be non-functional. Copyrights are protected for a limited term. The protection, though, extends significantly longer than patents. Typically, the term is the author's life plus a certain amount of additional time, depending on when the work was first published. So, for example, if a work was first published after 1978, the term is the author's life plus 70 years. It's also worth noting that copyright rights are conferred once the work is published. So they're often not registered because you do obtain copyright rights upon publication, but there are certain benefits to registration, especially registration if it's done early, particularly in the form of available remedies if you're enforcing your copyrights against someone else. And copyrights can be used to prevent others from copying or distributing copies of your work or substantially similar copies of your work.
And then the final type of IP right that we want to talk about are trade secrets. So, what is a trade secret? Well, it's information that provides a competitive advantage and is kept secret. So some famous examples are Kentucky Fried Chicken's recipe, the 11 herbs and spices, and also Coca-Cola's secret formula. But information can be something like a customer list or business strategy that you want to keep secret to it. So it's really any type of competitive information with a competitive advantage that can be kept secret. And it's also a perpetual right, so long as the owner takes reasonable steps to keep it secret. To that end, companies frequently will have to decide if they want to keep something they've invented, for instance, or if they have a process for manufacturing or a formula. They have to decide whether they want to try to keep it secret from competition so that they get a perpetual right to it, as opposed to making that secret public and then trying to get a patent on it, which would give them the ability to stop copiers for at least a fixed time period. Because if you don't get the patent and you keep it a trade secret, there's a that someone else will reverse engineer or figure out what the secret is. And the only way to stop them then is if they had somehow tried to copy, if they had somehow stolen the trade secret, as opposed to come up with it on their own or taking your product and working backwards to figure it out.
So now that we've set the stage and talked about the various types of intellectual property rights, we're going to jump into why those rights are valuable. So IP rights, they can create crucial benefits for companies. They can create barriers to entry and deter and prevent others from using your innovations or your brand names. They can enhance a company's reputation as an innovator and thought leader. They can encourage internal innovation within the company. They can also discourage litigation. They can increase a company's access to competitors' innovations. And ultimately, what this all leads to is that IP rights can increase a company's valuation. So we're going to jump in and touch on each of these benefits.
So the first benefit we want to talk about is creating a barrier to entry for others. So what do we mean by that? When you get IP rights, you put the competitor on notice about what your rights are. And so if they try to copy those rights, say a patent or trademark, they risk being sued. So the barrier there is that with your rights, you've now put them on notice, and they now risk being sued and brought into court if they try to infringe on those rights. And what happens when you're sued? Well, you have to expend time, money, and resources. The graph on the right shows just how expensive, for instance, patent litigation can be, ranging from anywhere from $500,000 to up to $5 million, depending on what kind of stakes there are in the case. And then, aside from just spending money on attorneys and other resources, you face potential money damages if you're sued. And then finally, and perhaps most importantly, you face the potential for being enjoined from making your product or from continuing to use a particular mark. or logo. So there's definitely a worry that if you copy, you're going to get sued. Aside from that, there's also just the risk of damaging your reputation. Most people do not want to be known as copycats, and it's not good for business in that sense. Aside from being sued, there's another barrier in that if they don't want to copy it and want to try to go their own route, they can try to design around whatever you've patented or trademarked and so forth. But that takes time, money, and resources. And then potentially you end up with a worse product so that the IP protected product ends up being a better product and more useful in commerce. The design around also doesn't necessarily get you out of the risk of being sued. So depending how close the design around gets to the patented invention or the trademark, it can still end up being sued. And then finally, hopefully the IP causes a competitor to just simply avoid the product altogether and stay out of that particular market.
Another benefit of IP rights is that they can enhance a company's reputation as an innovator or thought leader, and that helps in several ways. First, it can help with recruiting the best talent. Recruits may be attracted to joining a company that prioritizes IP rights and is an innovator in a particular field or industry. It can also help with a company's reputation among its customers and clients, and that could lead to potential additional sales or additional profits. It can also enhance a company's reputation with its vendors and partners, or potential vendors and partners who may be interested in partnering with a company that is known as an innovator. And finally, the scope of a company's IP rights can be useful from a marketing perspective. There are several publications that track the number of patents owned by companies in given time periods, and one example of those lists is shown on the slide, and it includes, in the companies with the top 10 number of patents in 2016, companies like IBM and Samsung and Google, which may be thought to be leaders and innovators.
So another value that IP adds is it encourages internal innovation at the company itself. So taking patents, for instance, companies often incentivize their employees to get patents, be it by giving money incentives and also reputation enhancing incentives. So the thought is that you get patents, you become a named inventor, you get a patent, that encourages you to innovate further to get an, and so forth and so on, and you create a self-perpetuating innovation cycle. The other, or another IP value that's added with IP is tool. So what do we mean by this? Is a good offense. When you have your own IP, it allows you to countersue a competitor who happens to sue you. So when you have your own rights that you can assert the person suing you. And what does that do? Well, if once you're in litigation, increases the chances of you yourself have something on the side. And then on top of that, it decreases potential exposure. You have potentially get your own in.
So having IP rights also provides an avenue to increase your access to competitors and others' innovations in a similar space. It can help with information gathering about competitors' innovations. Filing a patent application, you may conduct a search to see what else is out there in the space, and through that search, you may learn about innovations on competitors, or maybe so you can get information about competitors through the patent application process, and that information gathering can lead to potential licensing. So you may see that competitors where you may not be interested in staying in that space, so you may decide to license and obtain a royalty payment. It can also lead to information to take a lesson from someone else based on what rights they development rights that may be beneficial to each other. And touching on what Tim just mentioned on with respect to discouraging litigation and the negotiating leverage you may have, having your own IP rights provides negotiating leverage when you're negotiating potential licenses or a joint venture and development, and could lead to, you know, some sort of informal truce as opposed to some type of litigation. So what does this all lead to? All these benefits lead to an increase in the company's valuation. As shown in the chart, which shows the components of S&P 500 market value, intangible assets such as IP rights are the driving force behind gains. There's been a drastic shift from the 1970s where intangible assets were a very small percentage of market value to now where that number is almost 90% and has continued to grow. And why does this valuation matter? Are considering going public, and if you are considering getting involved in a potential merger or acquisition. And for small companies, that's particularly important because you may need venture capital funding so that you can continue to grow and potentially go public or be acquired at some point in the future.
So the next thing we want to talk about is how do you determine value? And so now we've talked about, you know, what are the IP rights, patents, trademarks, copyrights, trade secrets, so forth. Why are they valuable? We've gone through, you know, just how important these intangible rights have become in the 21st century. And now the question is, well, how do you determine, you have these IP rights, how do you determine if they're valuable or what their value is? So the first thing you need to do is evaluate an IP portfolio. So whether you are a company, you're looking at a company, however you're doing it, you want to review the IP. And how to do that is you want to talk to key innovators and employees at the company. Now, for companies that have you know, very large portfolios of thousands of patents or you know, numerous trademarks, you may want to be able to leverage technologies such as, you know, searching techniques and things like that through software. But generally, you're going to need to talk to key innovators and employees at the company to figure out what's there. This is sort of mining the IP. Then what you want to do is you want to screen that IP and kind of figure out what the important IP is. So you're going to have your key innovators and employees review that IP to tell you what the key IP is. And maybe this gets carved up into you know, categories of IP covering different technologies that the company uses or different brands that the company uses and trying to sift through what's the important intellectual property.
So what are you looking for when you are reviewing that IP? We want to figure out what the indicators of IP quality are. So one of those is portfolio size. And portfolio size may be an indication of a stronger portfolio. It may show resources invested by the IP holder and that the portfolio has been well planned. So that's one indicator. You also want to look at the prosecution of the IP rights. So we talked about the prosecution as the back and forth with the U.S. Patent and Trademark Office during the application process. And sometimes that back and forth can lead to a narrowing of rights. For example, if you have to explain why your invention is different than a prior invention, you may do so by somewhat narrowing your rights. And so you want to look at the prosecution quality. How did that impact the scope of your rights? You also want to look at the availability of continued prosecution. So particularly with patents, you can keep a patent family alive by filing you know, continuation applications and things like that. And so you want to do that in order to be able to ensure that the product that you ultimately end up practicing is covered by your patents. So you may need to file a continuation application that more specifically covers the product that you ultimately end up practicing, whereas when you filed the application, maybe the scope was a little bit different. And you want to make sure that you have the opportunity to potentially cover competitors who are attempting to design around but are still getting too close to your your invention. So you want to look at, is there available continued prosecution in the patent portfolio? You also want to look at the term. How much life is left in the IP rights? So this particularly comes into play with patents where there's a fixed term for the rights, and you want to see, do these patents have a lot of term left, or do they only have a couple of years left? And of course, if they have a longer term left in their life, then they can be more valuable than perhaps a patent that is nearing its end of life. Similarly, you want to make sure that the maintenance fees and renewal fees have been paid. So for both patents and trademarks, the Patent and Trademark Office requires that the rights holder submit periodic maintenance fees or renewal fees, and you want to make sure those have been properly maintained so that the rights are still valid and in force. If they haven't been, then you lose your rights potentially. You also want to look at the scope of the patents. So, does the scope cover the inventions that you practice? Is the scope broad such that it would cover potential design arounds, or is design around easy? If design around is very easy and could lead to a almost as successful or just as successful product, then perhaps the patent is more weak than if the technological scope is broad and would cover a variety of potential design arounds, or the design arounds would be of lesser quality. You also want to see when the patents were filed. Were they filed at an early part of the development stage, or were they continued, and do they cover what's currently being practiced? The corollary to that in trademarks is that when you file a trademark application, you have to identify the products and services that are covered by the application, and so when you're reviewing the IP rights, you want to make sure that the trademarks cover the products and services that you are actually practicing, and not just perhaps the initial product or initial services that were being offered when the mark was filed for. So you want to make sure that you have sufficient scope in your trademark rights as well. You also want to look at the international scope of the portfolio. So for example, if you are selling your product in the US and a handful of other countries, you want to make sure that those countries, so you have IP rights in those countries as well, and that's an indication of the quality of the portfolio. You also want to make sure that you have protection where the products are being manufactured as well, and that there's thought as far as where you plan to do those things in the future. So looking at the international scope is important for determining the quality of the rights. You also want to look at whether the IP rights have survived legal challenges, either in litigation or in Patent and Trademark Office proceedings. So if IP rights have survived those legal challenges, they may be indication of stronger IP rights than potentially others that have not. And finally, with trademarks, it's particularly important that you police your rights. One of the things I mentioned earlier is that to maintain your trademark rights, you have to police your rights or enforce them. And so you want to make sure when you're reviewing your IP portfolio that adequate steps have been taken to police your rights so that you haven't lost your rights or significantly narrowed them by allowing others to coexist with you by using similar marks.
So then sort of the last thing we want to look at for how do you determine value, you've reviewed the IP, you and your outside counsel have gone through and tried to figure out how valuable that IP is or the quality of the IP. The last thing you want to do is you want to identify competitors and target possibly potential licensees. So the IP really has value if, for instance, you know that there are competitors that are using very similar technology that might be covered by the IP. And then to that end, there's a possibility for potential licensing, where you can develop a revenue stream by getting royalties if you enter into license agreements with certain competitors. Or potentially you'll want to sue certain competitors. So you need to know who's out there, who's practicing in the field, how important is the IP that's being practiced in terms of, is this technology that's making money for the company? And we'll talk about now a little bit how you get into monetizing IP.
Yeah, so how do you monetize? Next question. There are several avenues for doing that. The first key avenue is that you can sell your IP rights. You can keep your core rights, for example, the ones that you are practicing that cover your core products that are the most important for your company. And you can raise money by selling fringe rights, such as rights that are nearing their end of life or that you aren't using. And you can make money by selling those off or potentially licensing them. And Tim's going to talk about shortly kind of the way you make that determination. Another option is that you sell everything. You sell your company and all of your IP. So an example of that is that Motorola Mobility sold itself and its 17,000 patents to Google for over $12 billion. Another option for selling your IP rights is to sell them to a patent assertion entity. And patent assertion entities are entities that have been created to essentially enforce patent rights against others. They acquire patents from a variety of different sources in order to send demand letters or file lawsuits to obtain money payments from other companies in settlements. So they are often looking to buy types of patents, often in the computer art space, and so that's one option for monetizing your patent rights. The other key area for monetizing your rights is by licensing them. So you can collect royalty payments by licensing IP rights as well.
And as Katie alluded to, there's a kind of a high-level way of looking at how important and how to monetize IP and how important that IP is. So this is an example for if you're looking at patents. You have a y-axis that gives you, strategic relevance. And what does that mean? Is the technology at issue that's been patented, is it technology that your company is actually going to use, or the company you're looking at is going to use? Is it technology that's not really being used at all? So if it's being used and that's the direction the company is going, obviously the strategic relevance is higher. If it's technology that's not of importance to the company's strategy, it's obviously lower. And along the x-axis, then you want to look also at patent quality. So those various features that Katie talked about in indicators of IP quality, you want to look at for the patent. So, has the patent been challenged and survived? Is there a long term left on the patent? All these different things. Is it broadly claimed? So you want to look at what the quality of the patent is. So if it's high, it's obviously better. If it's low, that's obviously worse. And then when you put this all together, when you look at both high strategic relevance and high patent quality, you get what's called core IP or core patenting. And what you do in that point is you can, attack competitors who are infringing on the patents, or you can license the patents, as we discussed, to try to get a stream of royalty payments coming in. If you take where there's high strategic relevance but potentially low patent quality, that's more of peripheral IP. And in that situation, you're probably going to be more inclined to license, keep the patents but license them, and then eventually sell them off. Then if you look at where you have a really high quality patent, but it's of low strategic relevance, it's not a product you're going to use, you want to definitely think about licensing, spinning off, or selling off that patent. And then you have where there's not, something's not strategically relevant. You're not going to be practicing that technology. It's some, side technology that you have to own a patent on, and the patent quality isn't very good. Well, obviously you don't want to hold on to that IP. You're probably better off selling it or abandoning it altogether. So we want to kind of wrap up here and talk about, what are the real world takeaways from all this? So we've talked about what the IP rights are. We've talked about how IP is valuable to a company's valuation. We've talked about how you can kind of go about determining that value, and we've also talked about ways of monetizing IP. So as Katie mentioned at the beginning, we have taken several clients where when they came to us, they didn't have a real sophisticated IP portfolio, and we have taken that IP portfolio, diversified it, and as they've become bigger companies. And so we wanted to kind of share just a few thoughts on, what have we learned in dealing with those situations. I think above all, the first thing we would mention is that, you want to look at, we've identified a bunch of various IP rights. You want to see, whenever you're at a company, looking at a company, have they protected things that they can protect as many ways as they can protect it. So a product could have a design patent on it. It could also have trade dress. It can also, the underlying technology, have utility patent for it. Software can be patented. It can also be copyrighted. So you want to see, are there different ways that the company has protected it to give it the most protection going forward as a company. Turning specifically to patents, a few things that we've sort of learned that is incredibly valuable is, for instance, getting patents early. So at the startup phase of a company, for instance, they're probably not going to be very focused on protecting or filing for patents. Part of it is that patents cost money. Another part of it is that they're going to be busy with getting the product out to market. They're not worried about that kind of stuff. They don't even know if the company is going to be successful. But you got to be vigilant about getting patents, because you're going to, if the product becomes successful, you're going to regret later if it hasn't gotten any patent protection. So you want to get patents early. As a corollary, you want to get patents often. So, company starts out, they sell 1 or 2 products. Let's say they sell products A, B, C. They think product A is going to be a big hit, so they try to get patents on it. They kind of neglect B and C. Well, lo and behold, 3 years later, product C is the thing that's really taken off, and now they don't have patent protection over it. So you want to diversify. You want to get patents over all that different technology, so you're ready if it hits. At least for commercial products, companies selling commercial products, you want to get design patents. I think one of the biggest regrets we've seen from companies is a failure to, before we got to them, a failure for them to get design patents. So Banner and Witkoff is a firm where we are big in the design patent world, and we really think it's highly recommended to get design patents, especially for commercial products. And then finally, Katie talked about this when she was talking about determining indicators of IP quality. You want to keep patent prosecution alive. So when a company files a patent, they may not know quite yet the important features of that product. So a product can be patented in a lot of different ways. Subsections can be patented. The overall idea can be patented. You don't know what's going to be important, and in maybe 2 or 3 years, a competitor has figured out what's really important about that product, and you want to make sure that you can draft claims that can cover that competitor. So keeping the patent prosecution alive allows you the opportunity to do that through what's called continuation applications.
So similar with patents, some of the takeaways we've seen with trademarks is companies should be registering early. This is going to be, for example, your brand name that you are going to invest a lot of resources in. You want to make sure to other people that can come out and use a similar name. And so by not registering early, you may lose some rights, you may lose some geographic scope, and so you want to make sure that you are registering your trademarks early. Also, by filing early, you may find out earlier if there's going to be challenges to your use and registration of the trademarks. So there are companies that have watches that pay attention to what's happening on the trademark registry, and they may notify you early on about potential issues with you adopting the mark. The trademark office may also cite applications against you that may indicate that there may be problems with using that trademark. So before you've invested significantly in the brand that you plan to, be the face of your company for years to come, you may want to find out about that early. So registering early can help with that. Registering often is also important. As Tim mentioned, you may not know what the successful products are going to be, and so oftentimes companies have sub-brands where they have their brand name, and then they have sub-brands for different product lines, and you may be focused on product line A, and product line C is the one that becomes successful. You may lose rights to that sub-brand by not registering that as well. So registering early, registering often, those are very important. For trademarks particularly, again, you want to police your marks. And so companies that don't do that often have regret that their rights become narrow because they didn't police their marks. There's a lot of third parties with similar marks or potentially similar trade dress designs. And if you haven't taken action, you lose your rights to those marks or designs. And so you want to make sure that they've been policed, even though the cost of policing can be expensive. It's very important to establish rights and to maintain rights. A very key area where we see companies expressing regret is where they didn't consider the international scope. If you ever intend to offer your products and services in other countries or manufacture in other countries, it's very, very important to obtain trademark registrations in those countries. And that's particularly important in countries like China, where there is a first to file system. So the first person to file the trademark in China can get protection. And oftentimes there are companies that are paying close attention to what's happening in the US trademark registry, and they are then filing applications in countries like China, and those applications can ultimately preclude you from obtaining registrations in those countries. They can also prevent you from potentially exporting your products from those countries. So for example, in China, if someone has a registration that they've registered with customs and you are manufacturing products using your mark in China and you want to export them, Chinese customs can stop you from doing that. So it's very important if you're going to be manufacturing in China or offering your products and services in China that you get your trademark applications on file very early. Another area where we see companies wishing they'd had certain things in place, so that we advise companies to put in place are proper employment agreements. So obtaining proper employment agreements early is very important. You want to make sure that the company owns the IP rights and not the employees. So, for inventions, the rights would be owned by the inventor, but you want to make sure that those are then assigned to the company. So having employment agreements that include language that the employee hereby assigns all of the IP rights to the company is very important. You similarly want to make sure that the employment agreements include confidentiality provisions and potential non-compete provisions, so that the employees aren't running off and starting their own companies or using your confidential information with other companies as well. Also important is making sure that there are work-for-hire agreements in place, and this is particularly applicable to copyrights. So oftentimes, companies work with advertising agencies or software development companies to develop advertisements or software, whether it's advertisements on TV or materials that will go along with packaging for a product or something like that. When companies are counterfeiters are out there, they oftentimes copy those product materials, and you want to make sure that you can enforce your rights against the counterfeiters that have done that. But if you don't have work for hire agreements in place with those agencies that have done that work, then you may not own the copyrights to those works. So making sure that there are work for hire agreements in place with respect to advertising agencies, software development agencies, or anyone else that's providing copyrightable works. You also want to make sure that you have agreements in place with manufacturers and suppliers. This is, again, particularly important if you are manufacturing in China, for example. There can be issues with who owns the equipment. Let's say you purchase equipment for your manufacturer in China. You want to make sure there's an agreement in place to address who owns that equipment, who owns any products that were overproduced, who owns, whatever's happening in those plants. You want to make sure there's an agreement in place that addresses that, because as it won't surprise many of you, a lot of the counterfeit products are made in China, and sometimes they're made on the same manufacturing plants as the legitimate products, and you want to make sure there's agreement in place to prevent that from happening. Similarly, with respect to suppliers, if you are in a joint venture agreement with a potential supplier or supplier, you want to make sure there's no question about who owns the IP rights. So obtaining agreements with those suppliers or joint ventures are very important.
So hold on. There we go. So that pretty much concludes what we wanted to. I think we wanted to just end by saying, you know, at each step of looking at IP value, you know, sifting through the IP, figuring out the prosecution of the IP, you know, thinking about how to monetize IP and all the above. And you know, that's what the kind of firm that we're here for. That's what we do. And we counsel clients in that all the time. So as you're looking at either companies you're looking at, or if you're at a company, if you're bringing a company through the exit strategy, or advising companies that are looking at companies, these are all things you want to look at for measuring the IP value of that company. So thank you very much. Happy to take any questions that anybody may have.
Perfect. Well, thank you very much, Katie and Tim. Appreciate it. We did have a few questions come in, so I'll go ahead and read those off. If you don't mind touching base on those, that'd be great. First question.
Yeah, absolutely.
Perfect. First question was, how do you protect original content like photos and poems that is published on a blog? Can the website and related posts be copyrighted, or does each individual photograph and poem need to be copyrighted?
Yeah, so the photographs and the poems, those are copyrighted once they're published. Once they're made public, you have copyright rights in them. However, if you want to enforce those rights, if someone's copying them and you want to file a lawsuit against them, you're going to need to register them. So you have the right just based on the publication of the poem or the photograph, but in order to enforce them in federal court, for example, you're going to need the registration, if that makes sense.
Perfect. Next question was, do individual employees of a company own/hold the patent, or does the company own it with the employee? And who did the work get named?
Sure. So the way the patent system works is that the inventor, who in this case would probably be the employee in this example, is the inventor on the